Hello everyone, welcome to Let's Crack UPSC CSE English. In our NCERT Marathon series, today we'll see continuation of Indian Constitution at Work, NCERT of 11th Standard, Part 6. Due to some reasons, in last session we have covered comparatively lesser time, but now today we'll start our marathon session for class 11th NCERT. It's my pleasure to welcome you all on Unacademy, India's largest learning platform. It's me, Rushikesh Inamdar, guiding UPSC aspirants from last 8 years. You can follow me on Unacademy and you can join our Telegram group using this link. Friends, we are announcing Unacademy Civil Services Championship, which is scheduled on 30th June from morning 10 a.m. to 12 p.m. It's absolutely free for all aspirants. Just you have to enroll yourself and participate in Unacademy Civil Services Championship. Here is the opportunity to win scholarship and prizes worth rupees 3 crore. The scholarship program like 25 to 100% scholarships, Unacademy physical notes you will get, and prizes like MacBook, iPad, iPhone, AirPods, and much more. So hurry up, enroll yourself for Unacademy Civil Services Championship and let's crack it. Yes friends, we are providing 4-in-1 offer which is limited period offer. We will discuss this offer in detail during the session. So in this offer you will get 4 benefits with single subscription like printed notes, mega subscription offer, no cost EMI benefit and discount. So we will discuss this offer in detail during the session. We are providing Unacademy paid subscription, that is plus an iconic subscription. So those aspirants pursuing their graduation or after their 12th examination planning to start their preparation for civil services, they must go with the iconic subscription. Now in this iconic subscription, aspirants will get all the features of plus course like live classes, structured courses, unlimited access and weekly tests. Along with that, additional features like personal guidance, study planner, study material, expert guidelines and test analysis. So it's my suggestion to those aspirants, go with iconic subscription. And if we are talking about plus and iconic subscription, where you will get 10% discount after using referral code RBI Live, which means for 2 years of plus subscription, you have to pay only 64,800 rupees after discount and using referral code RBI Live. And in iconic subscription, for 2 year subscription, you have to pay only 1,04,175 rupees after discount. And do not forget to use code RBI Live to avail 10% discount on your subscription. We are going to start new batch from 2nd June. We have 1 year, 2 year batches, NCERT batches and revision batches. Free test series for all aspirants. You have to just use code RBI Live to unlock the test. And Unacademy combat we are conducting on every Sunday morning 11 a.m. The combat is available in Hindi and English medium. So enroll yourself for this free Unacademy combat using code RBI Live. So let's start today's session. Indian Constitution at Work, Class 11 NCERT. So friends, as we have discussed in series of this NCRT, which will help you to understand the concept in polity section. Maybe you have optional subject or GS, it will help you. So we have covered constitution, why and half rights in the Indian Constitution, election and representation, executive, legislature, and judiciary. Now we'll start with the federalism today. Before that, we'll see the recap of last series, that is the chapter of judiciary in short, and then we'll continue today's topic, federalism. Fundamental duties are mentioned in the Constitution Part 4A, that is Article 51A, which talk about the fundamental duties. So in last session we have studied judiciary, where we have learned about why do we need an independent judiciary and how is this independence ensured. So the various measures or the provisions for the independence of judiciary in our constitution. Then we have discussed appointment of judges, removal of judges. Then we have discussed one unsuccessful attempt to remove a judge, that is in 1991. The event like Justice V. Ramaswamy case. Then we have covered the structure of judiciary. So friends, we have pyramidal structure in our country. Where the Supreme Court at the top, then high courts below them, district and subordinate court at the lowest level, we have discussed about the structure, that is Supreme Court of India, High Court, District Court and subordinate courts in detail. Then we have covered jurisdiction of Supreme Court, original jurisdiction, appellate jurisdiction, advisory jurisdiction, read jurisdiction and spatial powers of Supreme Court. We have discussed this jurisdiction in detail: original jurisdiction, read jurisdiction, appellate jurisdiction, and advisory jurisdiction. So friends, Article 137, which describes as the Supreme Court shall have power to review any judgment pronounced or order made by it, and Article 144, which describes as all authorities, civil and judicial, in the territory of India shall act in aid of the Supreme Court. Then we have discussed about judicial activism, public interest litigations, and we have covered one of the statement by Justice Bhagwati in Bandhuva Mukti Morcha versus Union of India 1984 case. So he described that He stated that it must be remembered that the problems of the poor are qualitatively different from those which have hitherto occupied the attention of the court and they need. So a different kind of judicial approach. So they need a different kind of judicial approach. And if we blindly follow the adversarial procedure in their case, they would never be able to enforce their fundamental right. Yes, fundamental rights. Then we have discussed about judicial activism in detail. Then we have covered judiciary and rights. So Article 32, which deals with the issuing writs by Supreme Court, or Article 226, have the power to issue such writs to high courts. So the practice of public interest litigation is now becoming more and more acceptable. So many courts across the world, particularly in South Asia and Africa, practice some form of judicial activism comparable to that of Indian judiciary. Then we had discussed about judiciary and parliament. Then we have also studied about the statement by Aladhi Krishna Swami Iyer in Constitution Assembly debate in 1949 about judicial independence. Yes, friends. So, in judiciary, we have studied the role of judiciary in our democratic structure. So, in spite of the tensions that arose from time to time between the judiciary and the executive and the legislature, the prestige of the judiciary has increased considerably. And at the same time, there are many more expectations from the judiciary. So, ordinary citizens also wonder how it is possible for many people to get easy acquittals and how witnesses change their testimonies to suit the wealthy and the mighty. So these are some issues about which our judiciary is concerned to. So we have seen that judiciary in India is very powerful institution, and this power has generated much awe and many hopes from it. So judiciary in India is also known for its independence. Through various decisions, the judiciary has given new interpretations to the constitution and protected the rights of citizens. So democracy hinges on the delicate balance of power between the judiciary and the parliament, and both institutions have to function within the limitations set by the constitution. So this way we have covered the complete judiciary. Yes, friends. Legal Services Day. Yes, this is given in the NCERT book 9/11/2018. So legal services authorities committed to protecting your legal rights. So legal services authorities aim to provide free legal aid and advice, spread legal awareness, organize lok adalats, promote settlement and disputes through ADA mechanism, and provide compensation to victims of crime. Yes. So following persons are eligible for free legal services. So there is criteria for the eligibility for free legal services. So women and children, members of scheduled caste or scheduled tribes, industrial workmen, persons with disability, victims of natural disasters, ethnic caste violence, industrial disaster, persons in custody, persons with an annual income of less than rupees 1 lakh or as notified by the central or state governments, and victims of human trafficking or beggar. Yes, these are the eligible for. Free legal services. Now, free legal services are provided in matters before civil, criminal, and revenue courts, tribunals, or any other authority exercising judicial or quasi-judicial functions. So, the following are the legal services, institutions for providing free legal services. So, at national level, National Legal Service Authority. At the state level, State Legal Services Authority. At taluka level, Taluka or Subdivisional Legal Services Committee. At High Court level, High Court Legal Services Committee. And at Supreme Court, Supreme Court Legal Services Committee. So friends, this is awareness campaign by the National Legal Services Authority, which is based in New Delhi. Access to justice for all. Yes. Now, we'll start with the next chapter. That is Federalism. Yes. Now tell me the federalism in single word. What is meant by federalism? Yes, friends. All right. Now, we'll start with the political maps of our country. Like the political map of India in 1947 and 2017. So they have dramatically changed, or they have changed dramatically over the years. Boundaries of states have changed, names of states have changed, and the number of states has changed. So when India became independent, we had a number of provinces that the British government had organized only for administrative convenience. Then a number of princely states merged with newly independent Indian Union, and these were joined to the existing provinces. So this is what we'll see in the next map. And since then, boundaries of states have been reorganized many times. So during this entire period, not only did boundaries of state change, but in some cases, even their names change according to the wishes of the people. of those states. Thus, Mysore changed to Karnataka and Madras became Tamil Nadu. So, the maps show these large scale changes that have taken place in the span of over 70 years. So, these maps also tell us the story of functioning of federalism in India. Yes. So now we'll study this chapter in detail. After end of the chapter, we'll be able to understand what is federalism, the federal provinces in the Indian Constitution, the issues involved in relation between the center and the states, and the spatial provisions for certain states having a distinct composition and historical features. Now see the India's map in 1947, where our country is divided into provinces for the administrative convenience by Britishers. From south we'll see Mysore, Bombay, Hyderabad, Central India, United Provinces. Then Bihar, Odisha, Punjab, Kashmir, West Pakistan. Yes. Now, after the 1947, now see the recent map, that is in 2017. Now friends, will see what is federalism. Yes. So we have to understand what is federalism and how it's beneficial or important for the administration purpose. So USSR, which Union of Soviet Socialist Republic, was one of the world's superpowers. But after 1989, it simply broke up into several independent countries. So friends, in 1989, USSR broke up into several independent countries. And one of the major reasons for its breakup was the excessive centralization and concentration of power. So, and the domination of Russia over the regions with independent languages and cultures of their own. So the reason behind that, to the separation or dividation into independent countries, there are various reasons in which one of the major reasons was the excessive centralization and concentration of power and the domination of Russia over other regions with independent languages and cultures of their own. Now, which means the Uzbekistan, for example, Uzbekistan. So some other countries like Yugoslavia, and Pakistan also had to face division of the country. Canada came very close to a break between the English speaking and the French speaking regions of that country. So, yes, Madhusudan, in today's session, we will cover class 11th NCERT's further topics like federalism. Yes, now we are understanding what is federalism. So, we are talking about the Canada. The Canada also came very close to breakup between the English speaking and the French speaking regions of that country. So it's a great achievement that India, which emerged as an independent nation state in 1947 after a painful partition, has remained united over 7 decades of its independent existence. So what accounts for this achievement? Now we'll understand all this in details. So can we attribute it to the federal structure of the governance that we in India adopted through our constitution? So all the countries mentioned above were federations. So yet they could not remain united. Therefore, apart from adopting a federal constitution, the nature of that federal system and the practice of federalism must also be important factors. Which means there should be a specific gravity to keep them united along with the constitution. So India is a land of continental proportions and immense diversities. There are more than 20 major languages and several hundreds minor ones. It is the home of several major religions. There are several million indigenous peoples living in different parts of the country. In spite of all these diversities, we share a common landmass. Yes, we have also participated in a common history, especially when we fought for independence. We also share many other important features. So this has led our national leaders to visualize India as a country where there is unity in diversity. So sometimes it is described as unity with diversity. Yes. Now, federalism does not consist of a set of fixed principles which are applied to different historical situations. Rather, federalism as a principle of government has evolved differently in different situations. So in American federalism, one of the first major attempts to build a federal polity is different from German or Indian federalism. But there are also few key ideas and concept associated with federalism. Yes, essentially, federalism is an institutional mechanism to accommodate two sets of polities, one at the regional level and other at the national level. So federalism is an institutional mechanism to accommodate two sets of polities, one at the regional level and the other at the national level. Each government each government is autonomous in its own sphere. In some federal countries, there is even a system of dual citizenship. But India has only a single citizenship. So the people likewise have two sets of identities and loyalties. They belong to the region as well as the nation. For example, we are Gujaratis or Jharkhandis as well as Indians. So each level of polity has distinct powers and responsibilities and has a separate government or separate system of government. So the details of this dual system of government are generally spelled out in written constitution, which is considered to be supreme and which is also the source of the power of both sides of government. So friends, certain subjects, yes, Anushka, today we are studying about remaining topics in class 11th NCRT, and now we are studying federalism. Just we have started the introduction of federalism. So where we have studied the examples throughout the world like USSR, Canada, or some other countries like Czechoslovakia, Yugoslavia, and Pakistan. Then the federalism basically is an institutional mechanism to accommodate two sets of polities, which is one at the regional level and the other at the national level. So the details of this dual system of government at the center and the regional level are generally spelled out in the written constitution, which is considered to be supreme and which is also the source of the power of both sides of government, which means the process of conducting administration at their sphere is mentioned in the written constitution. So this both at the national level and regional level, they are bound to follow constitution. Now, certain subjects which concern the nation as a whole, for example defense or currency, are the responsibility of the union, that is the central government, and regional or local matters are the responsibility of regional or state government. Now, to prevent conflicts between the center and the state, there is independent judiciary to settle disputes. The judiciary has the powers to resolve dispute between the central government and the states on legal matters about the division of power. Yes, we have discussed in judiciary chapter about this. So, Real politics, culture, ideology, and history determine the actual working of a federation. So, culture of trust, cooperation, mutual respect, and restraint helps federation to function smoothly. Yes, a culture of trust, cooperation, mutual respect, and restraint helps federations to function smoothly. Yes, this is practical in our real life too, in individuals as well. So, political parties also determine the way a constitution would work if any single unit or state or linguistic group or ideology comes to dominate the entire federation. It could generate a deep resentment among people or its unit not sharing the dominant voice. So these situations could lead to demand for succession by the aggrieved units or could even result in civil wars. The demand within the country for the separation or for the rights which lead to the civil wars. So many countries are embroiled in such conflict situations. Yes. Now see the newspaper cuttings which given into the NCRT book. Yes, friends. Like there are headlines. The states received funds. Yes. Now, during this discussion, I will understand the federalism in West Indies. Yes, friends. When we are studying the federalism in India, there are examples of other countries as well. So now we'll see the federalism in West Indies. So we may have heard about the cricket team of West Indies, but is there a country called West Indies? So like India, West Indies was also colonized by the British. So in 1958, the Federation of West Indies came into being. It had a weak central government and the economy of each unit was independent. So these features and political competition among the units led to the formal dissolution of the Federation in 1962. So later in 1973, by Treaty of Chiguaramas, the independent islands established joint authorities in the form of a common legislature, Supreme Court, a common currency, and to a degree, a common market known as the Caribbean Community. So the Caribbean Community has even a common executive and heads of governments of member countries are members of this executive. So thus, the units could neither live together as one country or nor can they live separately. Yes. Then we'll see the federalism in Nigeria. Yes. If the regions and various communities do not trust each other, Even a federal arrangement can fail to produce unity. So the example of Nigeria is instructive. So till 1914, northern and southern Nigeria were two separate British colonies. At the Ibadan Constitutional Conference of 1950, Nigerian leaders decided to form a federal constitution. So the three major ethnic groups of Nigeria, Yoruba, Igbo and Hausa Fulani, which control the regions of the west and the east and the north respectively. So at the west, Yoruba, in the east, Igbo, and in the north, Hausa Fulani. So their attempt to spread their influence to other regions led to fierce and conflicts. So these led to military regime. So in the 1960 constitution, both federal and regional governments jointly control the Nigerian police. So in the military supervised constitution of 1979, no state was allowed to have any civil police. Yes. So though democracy was restored in Nigeria in 1999, the religious differences along the conflicts over who will control revenues from the oil resources, which continue to present problems before the Nigerian Federation, and local ethnic communities, which resist centralized control of the oil resources. Thus, Nigeria is an example of overlap of religions, overlap of religious, ethnic, and economic differences among the units. Yes, friends, this is the federalism in West Indies and federalism in Nigeria. Yes. So friends, here is once again reminder for the Unacademy Civil Services Championship, which is scheduled on 13th June. Yes, 13th June from 10 a.m. to 12 p.m. So please participate in this championship. It's absolutely free for all aspirants. In this championship, you can attempt a live test where top rankers to get guidance from top UPSC CSE mentors. Yes, chance to win unique prizes like MacBook, iPad, iPhone and AirPods, and also scholarship worth rupees 3 crore. So hurry up, enroll yourself for Unacademy Civil Services Championship. We will provide link in the description box as well. Yes, friends. Now, continue with the federalism in the Indian Constitution. Federalism in the Indian Constitution. So even before independence, most leaders of our national movement were aware that to govern a large country like us, it would be necessary to divide the powers between provinces and the central government. So there was also awareness that Indian society had regional diversity and linguistic diversity. So this diversity needed recognition, people of different region and languages had to share power and in each region. So people of that region should govern themselves. This was only logical if we wanted a democratic government. So the only question was, what should be the extent of powers to be enjoyed by the regional governments? So in view of the agitation of the Muslim League for greater representation to the Muslims, a compromise formula to give very large powers to the regions was discussed during the negotiations before partition. And once the decision partition India was taken, the Constitution Assembly decided to frame government that would be based on the principles of unity, cooperation, which between the center and the states, and separate powers to the states. So friends, during the discussion of making our constitution, our constitution makers or the members of Constituent Assembly decided that to frame a government which would be based on the principles of unity and cooperation. That cooperation between the center and the states, and there should be separate powers to the states should be mentioned. So the most important feature of the federal system adopted by the Indian Constitution is the principle that relation between states and the center would be based on cooperation. So thus, while recognizing diversity, the Constitution emphasized unity. So I hope you are aware about the example that the Constitution of India does not even mention the word federation. So this is how the Constitution describes India. Yes. So in our Constitution, there is no specific word of federation mentioned, but our Constitution ensures the structure of federalism or the federalism nature in our country. So Article 1, Clause 1, where India, that is Bharat, shall be a union of states, and Clause 2, the states and the territories thereof shall be specified in the first schedule. So friends, Article 1, which is talked about the India, that is Bharat, shall be a union of states, and the states and the territories thereof shall be as specified in the first schedule. Yes, when we are talking about federalism in the Indian Constitution, so during the British regime or before the independence, the leaders from our national movement were aware about the importance of dividation of power or decentralization of power to govern a large country like India, which is mandated. So they aware about the Indian society had regional diversity and linguistic diversity. So through democratic government, it's possible to maintain this cooperation between states and union. So after the finalization of yes, when Britishers decided for the partition of our country, so they came to a decision that the sharing of power between center and state should be included in a constitution draft and which recognizing diversity and the unity in the nature. So the article 1 which describes as India, that is Bharat shall be union of states. Yes. So Madhusudan, it's like that. The combination of diversity. Now after that we'll see division of powers. So there are two sets of government which created by the Indian Constitution. One for the entire nation called the Union Government, also known as central government, and one for each unit or state which is called the state government. So both of these have constitutional status and clearly identified area of activity. Yes, if there is any dispute about which powers come under the control of the union and which under the states, this can be resolved by the judiciary on the basis of the constitutional provisions, which means judiciary makes sure that the interpretation of constitution to solving the matter related to the power distribution between center and the states. So the constitution clearly demarcates subjects which are under exclusive domain of the union and those under the states. So one of the important aspects of this division of powers is that economic and financial powers are centralized in the hands of the central government by the constitution. And the states have immense responsibilities but very huge revenue sources. Now see the chart. Union list, state list, concurrent list, and there are residuary powers. Now we'll see one by one. So friends, Constitution of India, which talked about the union list, state list and concurrent list. That is the sharing of power between center and state. So union list, which includes the subjects like defense, yes, subject related to national importance. So union list includes subjects like defense, atomic energy, foreign affairs, war and peace, banking, railways, post and telegraph, airways, ports, foreign trade, currency and coinage. So union legislature alone can make laws on these matters. Now we'll see second is state list. So state list includes subjects like agriculture, police, prison, local government, public health, land, liquor, trade and commerce, livestock, yes, livestock and animal husbandry, and state public services. So these are the subjects. So normally the state legislature can make laws on these matters. Then third is concurrent list. So concurrent list, which includes subjects like education, transfer of property other than agricultural land, forests, trade, unions, adulteration, adoption and succession. So both union and state legislation alone can make laws on these matters like education, transfer of property other than agricultural land, forests, trade unions, adulteration, adoption and succession. Then residuary powers. Which include all of the matters not mentioned in any of the lists, like cyber laws, union legislature alone has the power to legislate on such matters. That is residuary powers with the central or union government. Yes, now. So the divisions of powers which talked about the union, state and concurrent list. Now we'll see federalism with a strong central government. Yes friends. So it is generally accepted that the Indian Constitution has created a strong central government. So India is a country of continental dimensions with immense diversities and social problems. So the framers of the Constitution believe that we required a federal constitution that would accommodate diversities, but they also wanted to create a strong center to stem disintegration and bring about social and political change. So it was necessary for the center to have such powers because India at the time of independence was not only divided into provinces which created by the British, but there were more than 500 princely states which had to integrated. So federalism with a strong central government, where it is generally accepted that the Indian Constitution has created a strong central government. So India is a country of continental dimensions with immense diversities and social problems. So the framers of the Constitution, they believe that we required a federal constitution that would accommodate diversities, but they also wanted to create a strong center to stem disintegration and bring about social and political change. So it was necessary for the center to have such powers because India at the time of independence was not only divided into provinces which are created by the Britishers, but there were more than 500 princely states which had to be integrated into existing states or new states had to be created for them. So besides the concern for unity, the makers of the constitution also believe that the socio-economic problems of the country needed to be handled by a strong central government in cooperation with the states. So our constitution makers kept that concern in their mind, and the socio-economic problems needed to be handled by a strong central government in cooperation with the states. Now there is one remark by T.D. Krishnamachari in Constitutional Assembly debate in 1949, Constituent Assembly debate. So he stated that, let me tell my honorable friends in the house that the drift Like all constitutions has been towards the center. Because of circumstances that have now come into being, that the states have become so federal or unitary welfare states from being police states, and the ultimate responsibility as for the economic well-being of the country has become the paramount responsibility of the center. Yes, so one of the member of the Constituent Assembly, he stated about the federal structure in the country. So, poverty, illiteracy, and inequalities of wealth were some of the problems that required planning and coordination. Thus, the concerns for unity and development, which prompt the makers of the Constitution to create a strong central government. Now, let us look at the important provisions that create a strong central government, like the very existence of that create a strong central government. So the very existence of a state, including its territorial integrity, is in hands of the parliament. So the very existence of a state, including its territorial integrity, is in the hands of parliament. The parliament is empowered to form a new state by separation of territory from any state or by uniting two or more states. So it can also alter the boundary of any state or even its name. So the Constitution provides for some safeguards by way of securing the view of the concerned state legislature. So there are some important provisions that create a strong central government where the parliament is empowered to form a new state by separation of territory from any state or by uniting two or more states. So the parliament can also alter the boundary of any state or even its name. So the consultation provides for some safeguards by way of securing the view of the concerned state legislature regarding such matters. So the Constitution has certain very powerful emergency provisions which can turn our federal polity into highly centralized system once emergency is declared. So the Constitution has certain very powerful emergency provisions which can turn our federal polity structure into a highly centralized system once emergency is declared. So during an emergency, power becomes lawful centralized, and Parliament also assumes the power to make laws on subject within the jurisdiction of the states. Yes, as we know, when emergency proclaimed in any particular state, the complete administration and policy making of that state is under the central government. So even during normal circumstances, the central government has very effective financial powers and responsibilities. In the first place, items generating revenue are under the control of the central government. Thus, the central government has many revenue sources and the states are mostly dependent on the grants and financial assistance from the center. And secondly, India adopted planning as the instrument of rapid economic progress and development after independence. So, planning led to considerable centralization of economic decision making. So, Planning Commission appointed by the Union government is the coordinating machinery that controls and supervises the resources management of the states. So, besides, the Union government uses its discretion to give grants and loans to states, and this distribution of economic resources is considered lopsided and has led to charges of discrimination against states ruled by an opposition party. So, apart from emergency powers or emergency situation, in normal situation, the central government has very effective financial powers and responsibilities. So, the items generating revenue are under the control of the central government. And the union government uses its discretion to give grants and loans to states. So, the distribution of economic resources is considered lopsided and has led to charges of discrimination against states ruled by an opposition party. So, as we will study later, the governor has certain powers to recommend dismissal of the state government and the dissolution of the assembly. So, besides, even in normal circumstances, the governor has the power to reserve a bill passed by the state legislature for the assent of the president, and this gives the central government an opportunity to delay the state legislation and also to examine such bills and veto them completely. So there may be occasions when the situation may demand that the central government needs to legislate on matters from the state list. So this is possible if the move is ratified by the Rajya Sabha. So there may be occasions when the situation may demand that the central government needs to legislate on matters from the state list. And this is possible if the move is ratified by the Rajya Sabha. And the constitution clearly states that executive powers of the center are superior to the executive powers of the states. So furthermore, the central government may choose to give instructions to the state government, and the following extract from an article of the Constitution makes this clear. So Article 257 Clause 1, which describes as the executive power of the every state shall be exercised as not to impede or prejudice the exercise of the executive power of the union, and the executive power of the union shall extend to the giving of such directions to a state as may appear to the government of India to be necessary for that purpose. So Article 257 Clause 1, which talks about the executive powers of the center are superior to the executive powers of the states. Now we have already studied in the chapter on executive that we have an integrated administrative system. So the all India services are common to the entire territory. So the all India services are common to the entire territory of India, and officers chosen for these services serve in the administration of the states. Thus an IPS officer who becomes the collector, or an IPS officer who serves as the commissioner of police, are under the control of the central government, and states can neither take disciplinary action nor can they remove these officers from service. So Article 33 and 34, which authorize the parliament to protect persons in the service of the union or state in respect of any action taken by them during martial law to maintain or restore order, and this provision further strengthened the powers of the union government. So the Armed Forces Special Powers Act has been made on the basis of these provisions. So this act has created tensions between the people and the armed forces on some occasions. So in India, we have an integrated administrative system. The all India services are common to the entire territory. Yes, are common to the entire territory of India, and officers chosen for these services serve in the administration of the states. So these all India services officers are under the control of the central government. So states can neither take disciplinary action and nor can they remove these officers from service. Now, the Article 33 and Article 34, which authorize the Parliament to protect persons in the service of the Union or a state in respect of any action taken by them during martial law to maintain or restore order. So the Armed Force Special Power Act, APSPA, has been made on the basis of these provisions. Yes, friends, this is the federalism with a strong central government. Article 257(1), which talked about the executive powers of the Union. Now, friends, here is a reminder to all of you. Unacademy is providing 4-in-1 offer in which you will get printed notes worth ₹10,000 absolutely free with minimum 1 year subscription. In mega subscription offer, you will get extended validity on your subscription, which means you will opt for minimum 1 year subscription. Then you will get additional or extra validity of your subscription till next preliminary examination. That is in 1 year case or 1 year subscription case till the examination of 2022. Now, those aspirants facing financial constraint or challenges to start their preparation for UPSC CSE, Unacademy is providing loans for UPSC aspirants to enroll for the subscription on Unacademy platform, and 10% discount we are providing, where you can use referral code RBI Life to get 10% discount. So this is the 4-in-1 offer, which means 1 subscription, 4 benefits for the limited period offer. This offer is valid for minimum 1 year subscription. So you can go with 1 year, 2 year or 3 year subscriptions. So friends, hurry up and enroll yourself. Yes, now come to the point. Now we'll see the conflicts in India's federal system. So in the previous section, we have seen that the constitution has vested very strong powers in the center. Thus, the constitution recognizes the separate identity of the regions and yet gives more powers to the center. Once the principle of identity of the state is accepted, it is quite natural that the states would expect a greater role and powers in the governance of the state and the country as a whole. So, the states would expect a greater role and powers in the governance of the state and the country as a whole. This leads to various demands from the states. From time to time, states have demanded that they should be given more powers and more autonomy. This leads to tensions and conflicts in the relations between the center and the states. So while the legal disputes between the center and the states can be resolved by the judiciary, demands for autonomy are of political nature and need to be resolved through negotiations. So while the legal disputes between the center and the state can be resolved by the judiciary, So demands for autonomy are of political nature and need to be resolved through negotiations. Now we'll see center-state relations. The constitution is only a framework or a skeleton. Its flesh and blood is provided by the actual processes of politics. Hence, federalism in India has to large extent been influenced by the changing nature of the political process. So in 1950s and early 1960s, the foundation of our federalism was laid under Jawaharlal Nehru. So it was also a period of Congress dominance over the center as well as the states. So except on the issue of formation of new states, the relations between the center and the states remained quite normal during this period. So the states were hopeful that they would be making progress with the help of grants in aid from the center. So besides, there was considerable optimism about the policies of socio-economic development designed by the center. So center-state relations. The constitution is only a framework or a skeleton where its flesh and blood is provided by the actual processes of politics. So federalism in India has to large extent been influenced by the changing nature of the political processes. So here is the example of 1950s and early 1960s. The foundation of our federalism was laid under the Jawaharlal Nehru. So during that period, except on the issues of formation of new states, the relations between the center and the states remain quite normal, and there was considerable optimism about the policies of socio-economic development which designed by the center. Yes. So after that, in the middle of 1960s, the Congress dominance declined somewhat, and in large number of states, opposition parties came to power. Yes, in the middle of 1960s, the Congress dominance declined somewhat, and in a large number of states, opposition parties came to power. So it resulted in demands for greater powers and greater autonomy to the states. In fact, these demands were a direct fallout of the fact that the different parties were ruling at the center and in many states. So the state governments were protesting against what they saw as unnecessary interference in their governments by the Congress government at the center. And the Congress too was not very comfortable with the idea of dealing with governments led by opposition parties. In peculiar political context, which gave birth to a discussion about the concept of autonomy under a federal system, and finally, since the 1990s, Congress dominance has largely ended, and we have entered an era of coalition politics, especially at the center. So, in the states too, different parties, both national and regional, have come together or come to power, and this has resulted in a greater say for the states, a respect for diversity, and the beginning of more mature federalism. Thus, it is in the second phase that the issue of autonomy becomes very potent politically. Yes, the center-state relations after independence, then mid 1960s and then 1990s, it's completely a changing phase, transition phase we can say. Now we'll see demands for autonomy. So many states and even many political parties have from time to time demanded that states should have more autonomy, vice versa the central government. However, autonomy refers to different things for different states and parties. So sometimes these demands expect the division of powers should be changed in favor of the states, and more powers and important powers be assigned to the states. So in many states like Tamil Nadu, Punjab, West Bengal, many parties like DMK, Akali Dal, CPIM have made demand of autonomy from time to time. So another demand is that states should have independent source of revenue and greater control over the resources. So this is also known as financial autonomy. So in 1977, the left front government in West Bengal, which brought out a document demanding a restructuring of center-state relations in India, in the autonomy demands of Tamil Nadu and Punjab also, there was implicit support to the idea of greater financial powers. So the third aspect of the autonomy demands relates to administrative powers of the states, and states resent the control of the center over the administrative machinery. Now see, all right, yes, we'll take it your decision, Bhavesh. Yes, now the demands for autonomy, which means द स्वायत्तता राज्यों के द्वारा जो स्वायत्तता की डिमांड की गई थी, विच मीन्स राज्यों को कुछ आर्थिक यानी फाइनेंशियल ऑटोनॉमी की जो रिक्वायरमेंट्स थी, लाइक इन वेरियस रिसोर्सेस, दे डिमांडेड फॉर ऑटोनॉमी आफ्टर द इंडिपेंडेंस. हम बात करें 1977 उस वक्त the left front government was demanding financial autonomy. The left front government was demanding the restructuring of center-state relations in our country. जो रीजनल पार्टीज थी उनकी एक मांग थी कि सेंटर स्टेट रिलेशंस को रीस्ट्रक्चर किया जाए ताकि राज्यों को भी अहमियत दी जाए अलग अलग डिसीजन मेकिंग्स में, स्पेसिफिकली इन फाइनेंशियल पावर्स. Now there is one cartoon. So during discussion on national language in the Constituent Assembly, Nehru had to appeal to the Hindi-speaking provinces to show greater tolerance towards others. Now then, the autonomy demands may also be related to culture and linguistic issues. अलग अलग भाषाओं की हम बात करें तो हमारे देश में जो डाइवर्सिटी है, सो कई राज्यों ने जो डिमांड्स की थी ऑटोनॉमी की, वो उनके भाषा के आधार पर. सो द ऑपोजिशन टू द डोमिनेशन ऑफ हिंदी इन तमिलनाडु और डिमांड फॉर एडवांसिंग द पंजाबी लैंग्वेज एंड कल्चर are instances of this related to the autonomy. So some states also feel that there is a domination of the Hindi speaking areas over the others. In fact, during the decade of 1960s, there were agitations in some states against the imposition of Hindi language. So, 1960 के दौरान कुछ राज्यों में जो एजिटेशंस हुए थे, these are related to the imposition of Hindi language. Yes. Now, another cartoon given in the NCERT book, like when Nehru was appointing governors, some were reluctant to fit ministerial chairs. Now, after the autonomy or demand of autonomy, we'll see role of governors and president's rule. राज्यपाल का महत्वपूर्ण रोल, जो कि ड्यूरिंग द प्रेसिडेंट्स रूल इन द स्टेट्स, जो हम स्टडी करेंगे, लाइक द रोल ऑफ गवर्नर्स has always been controversial issues between the states and the central government. So the governor is not an elected office holder. So many governors have been retired military officers or civil servants or politicians. So besides, the governor is appointed by the central government, and therefore actions of the governor are often viewed as interference by the central government in the functioning of the state government. हम राज्यपालों की बात करें तो राज्यपाल इस पद पे जो भी अपॉइंटमेंट होती है वो द रिटायर्ड मिलिट्री ऑफिसर्स, सिविल सर्वेंट्स और पॉलिटिशियंस, और कई बार हमें स्टेट और सेंटर के बीच में जो संघर्ष है उसमें राज्यपाल और गवर्नर का जो रोल होता है वो बहुत इंपॉर्टेंट है. यस, सो when two different parties are in power in the center and the state, the role of the governor becomes even more controversial. So the Sarkaria Commission that was appointed by the central government सरकारिया कमीशन 1983 में जिसका गठन हुआ था और 1988 में सरकारिया कमीशन ने रिपोर्ट सबमिट किया था टू एग्जामाइन द इश्यूज रिलेटिंग टू सेंटर स्टेट रिलेशंस. यस, वन ऑफ द इंपॉर्टेंट कमीशन ऑन द सेंटर स्टेट रिलेशंस, सरकारिया कमीशन. फ्रेंड्स, कई बार प्री और मेंस में सरकारिया कमीशन रिलेटेड क्वेश्चंस पूछे गए हैं. So the Sarkaria Commission that was appointed by the central government to examine the issues relating to the center and state relations, which recommended that appointments of governors should be strictly non-partisan. Sarkaria Commission recommended that appointments of governors should be strictly non-partisan. So, powers and role of the governor, which become controversial for one more reason. On the most controversial articles in the Constitution is Article 356, which provides for President's rule So, Article 356, which provides for President's rule in any state, and this provision is to be applied when a situation has arisen in which the government of the state cannot be carried out in accordance with the provisions of this Constitution. Article 356 में जो राष्ट्रपति शासन के बारे में जिक्र किया गया है, when a state government cannot be carried out its function in accordance with the provisions of the Constitution, then there is a provision of President's rule in the state. Now, it results in the takeover of the state government by the union government, and the President's proclamation has to be ratified by the Parliament. So, President's rule can be extended till 3 years. राष्ट्रपति शासन 3 साल तक एक्सटेंड किया जा सकता है. So the governor has the power to recommend the dismissal of the state government and suspension or dissolution of state assembly. So this has led many conflicts. So in some cases, state governments were dismissed even when they had a majority in the legislature, as had happened in Kerala in 1959. एक ऐसी घटना 1959 में स्टेट असेंबली में मेजॉरिटी होते हुए भी केरला में राष्ट्रपति शासन लगाया गया था. So as had happened in Kerala in 1969, 1959. 1959 without testing their majority as happened in several other states after 1967. So some cases went to the Supreme Court and the court has ruled that constitutional validity of the decision to impose precedence rule can be examined by the judicial. Yes, the so Article 356 was very sparingly used till 1967. After 1967, many states had non-Congress governments and the Congress was in the power at the center. So the center has often used this provision to dismiss the state governments or has used the office of the governor to prevent the majority party or coalition from assuming office. So for instance, the central government removed elected governments in Andhra Pradesh and Jammu and Kashmir in the decade of 1980s. So Article 356 is talked about the emergency provisions. So 1980s में प्रेसिडेंट राष्ट्रपति शासन का उपयोग आंध्र प्रदेश और जम्मू कश्मीर में किया गया था 1980 के दशक में. So this is the role of governors and president's rule. Yes. Whenever you will get time, just read the cartoons given in the class 11th constitution. In Constitution at Work. Yes, in class 11th NCRT. Now, after that, we'll see important point, that is demands for new states. So the other dimensions of tension in our federal system has been the demand to create new states. नए राज्यों की मांग एक महत्वपूर्ण टॉपिक जो कि हमारे फेडरल सिस्टम्स में So the other dimension, like the national movement, not only created a pan-India national unity, it also generated distinct unity around a common language, region, and culture. So our national movement was also a movement for democracy, and therefore, in the course of the national movement itself, it was decided that as far as possible, states would be created on the basis of common culture and linguistic identity. राज्यों की संरचना उनकी भाषा कल्चर के आधार पर की जाए. So this ultimately led to demand for the creation of linguistic states after independence. In December 1953, the State Reorganization Commission was set up and it recommended the creation of linguistic states, at least for the major linguistic groups. So in 1956, reorganization of some states took place. So this saw the beginning of the creation of linguistic states, and the process is still continuing. Yes. So the national movement before independence was not only created a pan-India national unity, it also generated distinct unity around a common language, region, and culture. So after 1956, in 1960, the Gujarat and Maharashtra were created. Punjab and Haryana were separated from each other in 1966, and later northeastern region was reorganized and new states like Manipur, Tripura, Meghalaya, Mizoram, and Arunachal Pradesh were created. So in 2000, some of the largest states were further divided both to meet the demands for a separate state as well as to meet the need of greater administrative efficiency. Thus, Madhya Pradesh, Uttar Pradesh, and Bihar were divided to create three new states. So, like Chhattisgarh from Madhya Pradesh, Uttarakhand from Uttar Pradesh, and Jharkhand from Bihar was created. Then, recently in 2014, the state of Telangana was formed by dividing Andhra Pradesh. So, some regions and linguistic groups are still struggling for separate statehood, like Vidarbha in Maharashtra. Yes, 1960 में गुजरात और महाराष्ट्र ये दो राज्यों की निर्मित की गई थी. उसके बाद 1966 में पंजाब एंड हरियाणा, फिर नॉर्थ ईस्ट के स्टेट्स को निर्माण किया गया था. देन 2000 में मध्य प्रदेश, उत्तर प्रदेश, बिहार को डिवाइड करके छत्तीसगढ़, उत्तराखंड, झारखंड इन राज्यों की निर्मित की गई थी. एंड 2014 में तेलंगाना राज्य की निर्मित आंध्र प्रदेश से की गई थी. और अभी भी हमारे देश में कई ऐसे रीजन्स हैं, they are demanding a separate statehood, like Vidarbha in Maharashtra. Yes, now see the cartoon given in the NCRT, which talks about the flood demands for creating new states. The event was in July 1953. Yes, now interstate conflicts. Interstate conflicts. Yes. Now see, there is one query. Friends, in 1966, from Punjab, Haryana was created. So earlier it's a Punjab state, and then new full-fledged Haryana state, means previous Punjab state was divided into two states like Punjab and Haryana. So in 1966, Haryana separated from Punjab, and in 1966 this full-fledged Haryana state is in exist. Yes, now interstate conflicts. Now, while the states keep fighting with the center over autonomy and other issues like the share in revenue resources, there have been many instances of dispute between two states or among more than two states. So it is true that the judiciary acts as the arbitration mechanism on disputes of legal nature. But these disputes are in reality not just legal. So they have political implications, and therefore they can best be resolved only through negotiations and mutual understanding. So broadly, the two types of disputes keep recurring. So one is the border dispute. So states have certain claims over territories belonging to neighboring states. हम ऑटोनॉमी की बात करें तो फाइनेंशियल ऑटोनॉमी के अलावा, पास के अलावा रेवेन्यू रिसोर्सेस और अदर कई सारे इश्यूज हैं जो कि राज्य और यूनियन और बिटवीन दो राज्यों के बीच में कुछ डिस्प्यूट्स और कॉन्फ्लिक्ट्स हैं. So, border dispute. So states have certain claims over territories belonging to neighboring states, and though language is the basis of defining boundaries of the states. So often border areas would have population speaking more than one language. So it is not easy to resolve this dispute merely on the basis of linguistic majority. So one of the long-standing border disputes is the dispute between Maharashtra and Karnataka over the city of Belgaum. Manipur and Nagaland too have a long-standing border dispute. So the carving out of Haryana from the erstwhile state of Punjab has led to dispute between two states, not only over border areas, but over the capital city of Chandigarh. So this city today houses the capital of both these states. So in 1985, then Prime Minister Rajiv Gandhi reached an understanding with the leadership of Punjab, and according to this understanding, Chandigarh was to be handed over to Punjab, but this has not happened yet. Now, While border disputes are more about sentiment, the disputes over the sharing of river waters are even more serious. Along with the border issues, पानी का बंटवारा नदियों दो राज्यों के बीच में जो डिस्प्यूट्स है उसमें नदियों के पानी के डिस्प्यूट्स का भी एक अपना अहम रोल है. So the sharing of river waters are even more serious. So because they are related to problems of drinking water and agriculture in the concerned states. As agriculture is the backbone of our country and states, so these water disputes or the dispute over the sharing of river waters are even more serious. So you might have heard about the Kaveri water dispute. This is a major issue between Tamil Nadu and Karnataka. So farmers in both the states are dependent on Kaveri waters. Though there is a river water tribunal to settle water disputes, and this dispute has reached the Supreme Court. And in another similar dispute, Gujarat, Madhya Pradesh and Maharashtra are battling over sharing of waters of Narmada river. So rivers are a major resource, and therefore the disputes over river waters test the patience and cooperative spirit of the state. Now, then we'll see spatial provisions. The most extraordinary feature of the federal arrangement created in India is that many states get a different treatment. So we have already noted in the chapter on legislature that the size and population of each state being different and asymmetrical representation is provided in the Rajya Sabha, while ensuring minimum representation to each of the smaller states. This arrangement also ensures that larger states would get more representation. So in the case of division of powers, to the constitution provides a division of powers that is common to all the states. And yet the constitution has some special provisions for some states given their peculiar social and historical circumstances. So most of the special provisions pertain to the northeastern states, Assam, Nagaland, Arunachal Pradesh, Mizoram, etc. And largely due to their sizable integration or sizable indigenous tribal population with a distinct history and culture. But however, these provisions have not been able to stay. Alienation and the insurgency in parts of the region. So spatial provisions also exist for hilly states like Himachal Pradesh and some other states like Andhra Pradesh, Goa, Gujarat, Maharashtra, Sikkim and Telangana. So there are special provisions mentioned in the constitution सो कई राज्यों को जो स्पेशल प्रोविजंस का प्रावधान किया गया है, उन राज्यों के सामाजिक और ऐतिहासिक सर्कमस्टेंसेस के अकॉर्डिंगली उनको स्पेशल प्रोविजंस प्रोवाइड की गई है। तो जैसे कि नॉर्थ ईस्ट में असम, नागालैंड, अरुणाचल प्रदेश, मिजोरम और नॉर्थ ईस्ट स्टेट्स को स्पेशल प्रोविजंस प्रोवाइड की गई है। And the special provisions for hilly states like Himachal Pradesh and also some other states like Andhra Pradesh, Goa, Gujarat, Maharashtra, Sikkim and Telangana. Yes. Now we'll see the Jammu and Kashmir. So, after the special provisions for other states, now we'll see for Jammu and Kashmir. Now, the other states are getting various assistance from center due to their geographical features like hilly states and other states like have population for scheduled tribes and scheduled areas. Now we'll see that Jammu and Kashmir, the other state which had a special status was Jammu and Kashmir, JNK Article 370. Now understand, this article is repealed, so we'll understand from historical background. Yes, so Jammu and Kashmir was one of the large princely states which had option of joining India or Pakistan or remaining independent. During the independence procedure of our country, Britishers gave three options to Jammu and Kashmir princely state. Like, they had option of joining India or Pakistan or remaining independent. So however, immediately after independence, in October 1947, Pakistan sent trial infiltrators from its side to capture Kashmir, and this forced the Maharaja Hari Singh to ask for Indian help and acceded to the Indian Union. So many of the Muslim majority areas in the western and eastern parts joined Pakistan, but JNK was an exception. So under the circumstances, it was given much greater autonomy by the constitution. So according to Article 370, the concurrence of the state was required for making any laws in matters mentioned in the union and concurrent lists. This was different from the position of other states. So in the case of other states, the division of powers as listed through three lists automatically applies. In the case of Jammu and Kashmir, the central government had only limited powers and other powers listed in the union list and concurrent list could be used only with the consent of the state government. So here, earlier the status to implement the powers and various provisions, there should be consultation with state government is mandatory due to Article 370. So the central government had only limited powers and other powers listed in the union list and concurrent list could be used only with the consent of the state government. Not only consultation, but the consent of the state government. So this gave greater autonomy to the state of Jammu and Kashmir. So earlier, there was a constitutional provision that allowed the president with the concurrence of the state government to specify which parts of the union list should apply to the state. The president had issued two constitutional orders in concurrence with the government of Jammu and Kashmir, making large parts of the constitution which applicable to the state. So as a result, through Jammu and Kashmir had a separate constitution and a flag. So the parliament's power to make laws on subject in the union list was fully accepted. So the remaining difference between the other states and the state of Jammu and Kashmir were that no emergency due to internal disturbances could be declared in J&K without the concurrence of the state. Yes, the union government could not impose a financial emergency in the state. The union government could not impose a financial emergency in the state, and the directive principles did not apply in J&K. So, amendments to the Indian Constitution Article 368 could apply in concurrence with the government of Jammu and Kashmir. Yes, this was the situation in earlier days. Now at present, the special status given under 370, which is no longer exists. So, by the Jammu and Kashmir Reorganization Act 2019, the state has bifurcated into two union territories, that is Jammu and Kashmir and Ladakh. So the new arrangement has come into effect from 31st October 2019. So the two union territories, that Jammu and Kashmir with legislation or with assembly, and Ladakh without assembly. So the new arrangements come into effect from 31st October 2019. So this is the spatial provisions for other states and Jammu and Kashmir. Now we'll conclude the federalism. So federalism is like a rainbow where each color is separate and yet together they make a harmonious pattern. So federalism has to continuously maintain a difficult balance between the center and the states. No legal institutional formula can guarantee the smooth functioning of the federal polity. So ultimately, the people and the political process must be developed a culture and a set of values and virtues like mutual trust, toleration, and a spirit of cooperation. So federalism celebrates both unity as well as diversity. National unity cannot be built by streamlining differences. So such forces unity only, which generates greater social strife and alienation and tends finally to destroy unity. So responsive polity, sensitive to diversities and to the demands for autonomy, can alone be the basis of a cooperative federalism. Yes. So responsive polity sensitive to diversities and the demands for autonomy can alone be the basis of a cooperative federation. So this is all about the federalism. So we have talked about the federalism. What is federalism? The federal provisions in the Indian Constitution. Issues involve the relations between center and states, and the spatial provisions for certain states having distinct composition and historical features. So we have studied through the map of 1947 and 2017. Then we have discussed about what is federalism. So where we have discussed the example of USSR, Czechoslovakia, Yugoslavia, and Canada. So as India is a land of continental proportions and immense diversities, there are more than 20 major languages and several hundred minor ones. So it is the home of several major religions, and there are several million indigenous peoples living in different parts of the country. In spite of all these diversities, we share a common landmass. We have also participated in a common history and when we fought for independence. So unity in diversity or unity with diversity. So the federalism as a principle of government which evolved differently in different situations. So federalism is an institutional mechanism to accommodate two sets of polities, that is, one at the regional level and other at the national level. So each government is autonomous in its own sphere. So in some federal countries, there is even a system of dual citizenship, but India has only single citizenship. Then we have discussed about the conflicts between center and states. So there is an independent judiciary to settle these disputes. Constitution is supreme. Then a culture of trust, cooperation, mutual respect and restraint, which helps federation to function smoothly. Then we have discussed about the federalism in West Indies and Nigeria. Then federalism in the Indian Constitution. So Article 1, which talks about the India, Article 1, Clause 1, India, that is Bharat, shall be a union of states, and the states and the territories thereof shall be as specified in the first schedule. Now, division of powers. We have discussed about union list, state list, concurrent list, and residual powers, residuary powers. of the central government. Then federalism with a strong central government. So, our framers of the constitution believe that we required federal constitution with a strong center to stem disintegration and bring about social and political change. So, at the time of independence, a country was not only divided into provinces, which created by British, but there were more than 500 princely states which had to be integrated into existing states, or new states had to be created. Then we have discussed about Article 257 Clause 1, where the executive power of the center. So the executive power of every state shall be so exercised as not to impede or prejudice the exercise of the executive power of the union. And the executive power of the union shall extend to the giving of such directions to a state as may appear to the government of India to be necessary for that purpose. Yes, we have studied about the integrated administrative system in executive chapter. So Article 33, Article 34, which authorizes the Parliament to protect persons in the service of the Union and a state. There is the provision of Armed Force Special Power Acts. Then we have discussed about the conflicts in India's federal system for more power and more autonomy. Then we have discussed about center-state relations, demands for autonomy, like autonomy for financial autonomy, or the autonomy demands also related to the cultural and linguistic issues. Then we have covered role of governors and president's rule. Yes, power and role of the governor become controversial for one more reason. So one of the most controversial articles in the constitution is Article 356, which talks about the president's rule in any state. Then we have discussed about demands for new states, interstate conflicts, like for the border disputes and sharing of river waters. And then we have discussed about spatial provisions for few states and Jammu and Kashmir. Yes. Now after the federalism, friends will see local governments. So local governments, well, now we'll talk about introduction. So in a democracy, it is not sufficient to have an elected government at the center and the state level, it is also necessary that even at the local level, so there should be an elected government to look after the local affairs. So in this chapter, we'll study the structure of the local government in our country. So in democracy, if we are talking about the stages of administration or governance, so from the base like local level or local governments, then state and center government. So in democracy, it's not sufficient to have an elected government at the center and the state level. So it is also necessary that even at the local level, there should be an elected government to look after local affairs. So now we will study the structure of local government in our country, and will also study importance of the local governments and ways to give them independent powers. So now, after finishing this chapter, we'll know about the importance of local government bodies, the provisions made by the 73rd and 74th amendments, functions and responsibilities of the local government bodies. So why local governments? Why there is need of local government? So now there is a story. We will cover that story as well. Now, Geeta Rathod belongs to Jamonia Talab Gram Panchayat, Sehot district, Madhya Pradesh. She was elected Sarpanch in 1995 from a reserved seat. But in 2000, the village people rewarded her for her admirable work by electing her again, and this time from a non-reserved seat. From a housewife, Geeta has grown into a leader displaying political farsightedness. She has harnessed the collective energy of her panchayat to renovate water tanks, build a school building, construct village roads, fight against domestic violence and atrocities against women, create environmental awareness, and encourage afforestation and water management in her village. So Panchayati Raj. So this is the Panchayati Raj update, volume 11, number 3, February 2004. So friends, this story which talked about the participation of women in local governments. Now there is another story of yet another woman achievement. She is the president, that is the Sarpanch of Gram Panchayat in Vengai Vasal village in Tamil Nadu. In 1997, the Tamil Nadu government allotted 2 hectares of land to 71 government employees, and this piece of land fell within the vicinity of this Gram Panchayat. So on the instructions of higher authorities, the district collector of Kanchipuram directed the president of the Gram Panchayat to pass a resolution endorsing the allotment of the said land for the purpose already decided. So the president and the Gram Panchayat refused to pass such an order, and the collector issued an order to acquire the land. So the Gram Panchayat filed a writ petition in the Madras High Court against the collector's action. The single judge bench of the High Court upheld the collector's order and ruled that there was no need to take the Panchayat's consent. The Panchayat appealed to the division bench against the single judge's order. Now, in this order, the division bench reversed the order of the single judge, and the judges held that the government order amounted to not only infringement of the power of the panchayats, but a gross violation of constitutional status of the panchayats. So friends, both these stories were a small village from Madhya Pradesh, जहां पे गीता नाम महिला जिन्होंने एज प्रधान के पद पे बहुत अच्छा काम किया, और सेकंड एग्जाम्पल जो तमिलनाडु में where a woman president of the panchayat fought for the people and their rights and the powers of or the status of panchayat constitutional to save the constitutional status of the panchayat. Now, both these stories are not isolated incidents. They are representative of a larger transformation that is taking place across India, especially after constitutional status was accorded to local government institutions in 1993. So local government is government at the village and district level. Local government is about government closest to the common people. Local government is about government that involves the day-to-day life and problems of ordinary citizens. Local government, which believes that the local knowledge and local interest are essential ingredients for democratic decision making, and they are also necessary for efficient and people friendly administration. So the advantage of local government is that is so near the people. So the local government is about government closest to the common people. So these two small stories regarding the power of the local governments and their representation. So the advantage of local government is that is to so near to the people and they are serving people with their needs. So it is convenient for the people to approach the local government for solving their problems both quickly and with minimum cost. Yes, in the story of Geeta Rathod, we notice that she was able to bring about a significant change in Jamunia Talab because of her proactive role as Sarpanch of the Gram Panchayat. Vengay Vessel village is able to still retain its land and the right to decide what to do with it because of the relentless efforts of its Gram Panchayat president and members. So local governments can be very effective in protecting the local interest of the people. So when we are talking about democracy, so democracy is about meaningful participation. It is also about accountability. Strong and vibrant local governments ensure both active participation and purposeful accountability. So Geeta Rathod's story is one of committed participation, and Vengay Vessel village Gram Panchayat's relentless efforts to secure its rights over its own land were an example of a mission to ensure accountability. So it is at the level of local government that common citizens can be involved in decision making which concerning their lives, their needs, and above all their development. So it is necessary that in a democracy, tasks which can be performed locally should be left in the hands of the local people and their representatives. So common people are more familiar with their local government than with the government at the state or national level. Yes, they are also more concerned with what local government does or has failed to do, as it is has direct bearing and impact on their day-to-day life. Thus, strengthening local government is like strengthening democratic process. So हमारे लोकतंत्र में लोकल गवर्नमेंट्स का बहुत बड़ा योगदान है. हम छोटे से छोटे एग्जाम्पल से ये देख सकते हैं. कॉमन मैन जो भी अपने जो भी इश्यूज है वो बहुत इजीली लोकल गवर्नमेंट और रिप्रेजेंटेटिव्स के साथ शेयर कर सकता है, जिससे समय की बचत और धन की बचत होके वो अपने काम को अंजाम दे सकता है. सो लोकतंत्र में लोकल गवर्नमेंट का बहुत महत्वपूर्ण योगदान है. सो स्ट्रेंथनिंग लोकल गवर्नमेंट is like strengthening democratic process. Now we'll see growth of local government in India. So let us now discuss how local government has grown in India and what our constitution says about it. So it is believed that self-governing village, yes, self-governing village communities existed in India from the earliest times in the form of sabhas, that is village assemblies. So in the course of time, these village bodies took the shape of panchayats, an assembly of 5 persons, and these panchayats resolved issues at the village level. Their role and functions kept on changing at different points of time. So in modern times, elected local government bodies were created after 1882. So Lord Ripon, who was the Viceroy of India at that time, took the initiative in creating these bodies. They were called the local boards. However, due to slow progress in this regard, the Indian National Congress urged the government to take necessary steps to make all local bodies more effective. Following the Government of India Act 1919, village panchayats were established in a number of provinces, and this trend continued after the Government of India Act 1935. Yes, So in modern times, the elected local government bodies were created after 1882. So Lord Ripon, who was the Viceroy of India at that time, who took initiative in creating these bodies. So they were called local boards. I hope when we were discussing with our grandfathers, they are talking about these local boards and administration before independence. So, however, due to slow process in this regard, the Indian National Congress urged the government to take necessary steps to make all local bodies more effective. Now, following the Government of India Act 1990, yes, 1990, village panchayats were established in number of provinces, and this trend continued after the Government of India Act of 1935. So during India's freedom movement, Mahatma Gandhi had strongly pleaded for decentralization of economic and political power. So friends, in present situation also, we are always talking about decentralization of economic and political power. So he believed that strengthening village panchayats was a means of effective decentralization. All development initiatives must have local involvement in order to be successful. Panchayats, therefore, were looked upon as instruments of decentralization and participatory democracy. So our national movement was concerned about the enormous concentration of powers in the hands of the Governor General sitting at Delhi. So therefore, allegiance, independence mean an assurance that there will be decentralization of decision making, executive and administrative powers. So the independence of India should mean the independence of the whole of India, and independence must begin at the bottom. So thus every village will be a republic. So it follows therefore that every village has to be self-sustained and capable of managing its affairs. So in this structure, composed of innumerable villages, there will be ever widening, ever ascending circles. Then life will be a pyramid with the apex sustained by the bottom. So yes, these are the lines by Mahatma Gandhi. So Gandhiji was always talked about the growth and prosperity of villages through various steps. Now, when the constitution was prepared, the subject of local government was assigned to the states. So it was also mentioned in the directive principles as one of the policy directives to all governments in the country. as we have read earlier chapters, that is being a part of directive principle of state policy. This provision of constitution was non-justiciable. So DPSPs are not non these are the form of non-justiciable and primarily advisory in its nature. So it is felt that the subject of local government, including panchayats, did not receive adequate importance in the constitution. So the subject of local government, including panchayats, did not receive adequate importance in the constitution. So do you know why this happened? A few reasons can be advanced here. Firstly, the turmoil due to the partition resulted in a strong unitary inclination in the constitution. Nehru himself looked upon extreme localism as a threat to unity and integration of the nation. Secondly, there was a powerful voice in the Constituent Assembly led by Dr. B.R. Ambedkar, which failed at the faction and caste-ridden nature of rural society would defeat the noble purpose of local government at the rural level. So, firstly, the turmoil due to the partition resulted in strongly unitary inclination in the constitution. Nehru himself looked upon extreme localism as a threat to unity and integration of the nation. And secondly, there was a powerful voice in the Constituent Assembly led by Dr. B.R. Ambedkar, which failed that the faction and caste-ridden nature of rural society would defeat the noble purpose of local government at the rural level. So, however, nobody denied the importance of people's participation in the development planning. So, many members of the Constituent Assembly wanted village panchayats to be the basis of democracy in India, but they were concerned about factionalism and many other ills present in the villages. Yes, when we are talking about inclusive growth, in after the period of independence, at the village level, there are different ills like caste system and the factionalism due to various factors. So during that period, it's not possible to achieve the goal decided by the constitution makers. But they were, they were deciding the importance of people's participation. So, in the interest of democracy, the villages may be trained in the art of self-government, even autonomy. So we must be able to reform the villages and introduce the democratic principles of government there. So in the interest of democracy, the villages may be trained in the art of self-government and even autonomy. We must be able to reform the villages and introduce democratic principles of government there. Yes, these are the words by the Anantha Sayaman Iyengar in the Constituent Assembly debate. He talked about the importance of the local government in autonomous and self way. Now we'll see how local governments in independent India. Yes. Now we'll see local governments in independent India. So local governments got a fillip after 73rd and 74th Constitutional Amendment Acts. But even before that, some efforts in the direction of developing local government bodies had already taken place. So, in the line was the Community Development Program in 1952, which sought to promote people's participation in local development in a range of activities. So, in this background, a three-tiered Panchayati Raj system of local government was recommended for the rural areas. So some states like Gujarat, Maharashtra adopted the system of elected local bodies around 1960. But in many states, those local bodies did not have enough powers and functions to look after the local development. They were very much dependent on the state and central governments for financial assistance. Many states did not think it necessary to establish elected local bodies. So in many instances, local bodies were dissolved and local government was handed over to government officers. So many states had indirect elections to most local bodies, and in many states, elections to the local bodies were postponed from time to time. Now, after 1987, a thorough review of the functioning of local government institutions was initiated. So, in 1989, the P.K. Thangon Committee recommended constitutional recognition for the local government bodies and a constitutional amendment to provide for periodic elections to local government institutions and enlistment of appropriate functions to them. So along with funds was recommended. So basically after 1987, a thorough review of the functioning of local government institutions was initiated. So in this purpose, in 1989, the P.K. Thangon Committee recommended constitutional recognition for the local government bodies. So a constitutional amendment to provide for periodic elections to local government institutions and enlistment of appropriate functions to them along with funds was recommended. So the local governments in independent India, now we'll see the 73rd and 74th Constitution Amendment Acts in detail. So in 1989, the central government introduced two constitutional amendments. These amendments aim at strengthening the local governments and ensuring an element of uniformity in their structure and functioning across the country. So friends, the Constitution of Brazil has created states, federal district and municipal councils. Each of these is assigned independent powers and jurisdiction. Just as the republic cannot interfere in the affairs of the states except on grounds provided by the Constitution. So states are prohibited from interfering in the affairs of the municipal councils, and this provision protects powers of the local government. So now come to India. Later in 1992, the 73rd and 74th constitutional amendments were passed by the Parliament. So the 73rd Constitution Amendment is about rural local governments, which are also known as Panchayati Raj institutions or PRIs, and 74th Amendment made the provisions relating to the urban local government, like for Nagar Palikas. So the 73rd and 74th Amendments came into force in 1993. So we have noticed earlier that the local government is a state subject. States are free to make their own laws on this subject. But once the Constitution was amended, the states had to change their laws about local bodies. In order to bring this conformity with the amended Constitution. So they were given 1 year's time to making necessary changes in respective state laws in the light of these amendments. So local government is a state subject, and after the amendment of 73rd or 74th constitutional amendments, states were given 1 year's time to making necessary changes in their respective state laws to adopt the constitutionalization of local governments. Now we'll see 73rd Amendment in detail. So let us now examine the changes brought about by the 73rd Amendment in Panchayati Raj institutions. Three-tier structure. So all states now have a uniform three-tier Panchayati Raj structure. So at the base is the Gram Panchayat. A Gram Panchayat covers a village or group of villages. The intermediary level is the mandal and also referred at some states as block or taluka. So these bodies are called mandal or taluka panchayats. So the intermediary level body need not be constituted in smaller states. So at the apex is the Zila Panchayat, which covering entire rural area of the district. So in the three-tier structure, all states now have a uniform three-tier Panchayat Raj structure. So at the base is the Gram Panchayat, the intermediary level is the Mandal, which is also known as block or taluka. Yes, at the Mandal level, that is Mandal or Taluka Panchayats. And after that, the apex is the Zila Panchayat or Zila Parishad, which covering the entire rural area of the district. The amendment also made a provision for the mandatory creation of the Gram Sabha. The Gram Sabha would comprise all the adult members registered as voters in the Panchayat area. Its role and functions are decided by state legislation. So this is the three-tier structure. So Gram Panchayat, Taluka Panchayat and Zila Panchayat or Zila Parishad. Now just remember that the intermediary level body, which means Mandal or Taluka Panchayats, not be constituted in smaller states. So there are only Zila Panchayat or Zila Parishad and the Gram Panchayat. Now after that, under the 73rd Constitution Amendment, the provision of elections. So all the three levels of Panchayati Raj institutions are elected directly by the people. The term of each Panchayat body is 5 years. So all the three levels of Panchayati Raj institutions are elected directly by the people. The term of each Panchayat body is 5 years. If the state government dissolves the Panchayat before the end of its 5-year term, fresh elections must be held within 6 months of such dissolution. And this is an important provision that ensures the existence of elected local bodies. So before the 73rd Amendment, in many states, there used to be indirect elections to the district bodies, and there was no provision for immediate elections after dissolution. So the 73rd Constitutional Amendment provided elections then reservations. So 1/3 of the positions in all Panchayat institutions are reserved for women. So in 73rd Constitution Amendment, there is provision of reservations. So 1/3 of the positions in all panchayat institutions are reserved for women. So 1/3 of the positions in all panchayat institutions are reserved for women. So reservations for scheduled castes and scheduled tribes are also provided for at all the three levels in proportion to their population. If the states find it necessary, they can also provide for reservation for the other backward classes. So the 1/3 of the positions in all panchayat institutions are reserved for women. So reservations for scheduled castes and scheduled tribes are also provided for at all the three levels in proportion to their population. So if the states find it necessary, they can also provide for reservations for other backward classes, OBCs. Now it is important to note that these reservations apply not merely to ordinary members in panchayats, but also to the positions of chairpersons or adhyakshas at all the three levels. Then further, reservation of 1/3 of the seats for women is not merely in the general category, yes, general category of seats, but also within the seats reserved for scheduled castes, scheduled tribes, and backward castes. This means that a seat may be reserved simultaneously for a woman candidate and one belonging to scheduled caste or scheduled tribes. Thus, the sarpanch would have to be a Dalit woman or an Adivasi woman. So the 73rd Constitution Amendment Act is also talked about reservations. Then, next is transfer of subjects. "29 subjects which were earlier in the state list of subjects are identified and listed in the 11th schedule of the Constitution. So these subjects are to be transferred to the Panchayati Raj institutions. These subjects were mostly linked to the development and welfare functions at the local level. So the actual transfer of these functions depends upon the state legislation, and each state decides how many of these 29 subjects would be transferred to the local bodies. Now, Article 243G. So, Article 243G, which talks about the powers, authority, and responsibilities of panchayats. The legislature of a state may, by law, endue the panchayats with such powers and authority with respect to the matters listed in the 11th schedule. So the Article 243G, which talks about the powers, authority, and responsibilities of panchayats. The legislature of a state may, by law, endue the panchayats with such powers and authority with respect to the matters listed in the 11th schedule. So this is Article 243G. Now we'll see some least subjects listed in the 11th schedule. So friends, agriculture, minor irrigation, water management, watershed development, then small scale industries including food processing industries, rural housing, drinking water, roads, culverts, rural electrification, poverty alleviation program, education including primary and secondary schools, technical training and vocational education, adult and non-formal education, libraries, cultural activities, markets and fairs, then health and sanitization, including hospitals, primary health centers, dispensaries, then family welfare, women and child development, social welfare, welfare of the weaker sections, and in particular of the scheduled caste and the scheduled tribes. Then public distribution system. Friends, these are the some subjects listed in the 11th schedule. Agriculture, minor irrigation, water management and watershed development, small scale industries, including food processing industries, rural housing, drinking water, roads, culverts, rural electrification, poverty alleviation program, education including primary and secondary schools, technical training and vocational education, adult and non-formal education, libraries, cultural activities, markets and fairs, health and sanitization, including hospitals, primary health centers and dispensaries, family welfare, women and child development, social welfare, welfare of the weaker sections, and in particular of the scheduled caste and the scheduled tribes, and public distribution system. So the Article 243G, which talked about the powers and authority and responsibilities of panchayats and the legislature of a state, may by law endow the panchayats with such powers and authority with respect to the matters listed in the 11th schedule. Now, the provisions of the '73rd Amendment were not made applicable to the areas inhabited by the Adivasi populations in many states of India. In 1996, a separate act was passed extending the provisions of the panchayat system to these areas. Many Adivasi communities have their traditional customs of managing common resources such as forest and small water reservoirs. So therefore, the new act protects the rights of these communities to manage their resources in ways acceptable to them. For this purpose, more powers are given to the Gram Sabhas of these areas, and elected village panchayats have to get the consent of the Gram Sabha in many respects. So the idea behind this act is that local traditions of self-government should be protected while introducing modern elected bodies. And this is only consistent with the spirit of diversity and decentralization. Then there is provision of state election commissioners. Yes, after the transfer of subject reservations elections and three-tier structure, 73rd Amendment is provided with the provision of state election commissioners. The state government is required to appoint a state election commissioner who would be responsible for conducting elections to the Panchayati Raj institutions. So earlier, this task was performed by the state administration, which was under the control of the state government. Now the office of the state election commissioner is autonomous like the election commissioner of India, and however the State Election Commissioner is an independent officer and is not linked to, nor is this officer under the control of the Election Commission of India. So the State Election Commissioners, the provision of this is under 73rd Constitution Amendment Act. So the state government is required to appoint a state election commissioner who would be responsible for conducting elections to the Panchayati Raj institutions. Earlier, this task was performed by the state administration, which was under the control of the state government. Now, the office of the state election commissioner is autonomous like the election commissioner of India. So, however, the state election commissioner is an independent officer and is not linked, nor is this officer under the control of the Election Commission of India. Yes. After that, State Finance Commission. So under this Constitution Amendment, the state government is also required to appoint a State Finance Commission once in 5 years. So this commission would examine the financial position of the local governments in the state. It would also review the distribution of revenues between the state and local governments on the one hand and between rural and urban local governments on the other. So the State Finance Commission also reviewed the distribution of revenues between the state and local governments on the one hand and between rural and urban local governments on the other. So this innovation ensures that allocation of funds to the rural local governments will not be political matter. So the provision of State Finance Commission. Now we'll see 74th Amendment in the next part. So now we'll just have a recap what we have discussed. So we have started with the federalism in today's session, where we have covered the introduction of federalism, then what is federalism, federalism in West Indies and Nigeria. Yes friends, do not forget to participate in Unacademy Civil Services Championship, which is scheduled on 13th June between 10 am to 12 pm. It's absolutely free, so enroll yourself. And here is the chance to win scholarship and prizes worth rupees 3 crore. Then we have discussed about the federalism in the Indian Constitution. We have discussed about Article 1, Clause 1. India is that is Bharat, shall be a union of states. And second, clause second, the states and the territories thereof shall be specified in the first schedule. Then we have discussed about divisions of powers between union and state through the union list, state list, concurrent list, and residuary powers, which are mentioned in the Constitution of India. Federalism with a strong central government. Yes. Article 257 clause 1, which talks about the executive power of every state shall be so exercised as not to impede or prejudice the exercise of the executive power of the union, and the executive power of the union shall extend to the giving of such directions to state as may appear to the government of India to be necessary for that purpose. And we have discussed about Article 33, 34. Yes, friends, do not forget to enroll yourself under the 4-in-1 offer. This is the limited period offer where you will get printed notes worth rupees 10,000 absolutely free with minimum 1 year subscription. Then mega subscription offer in which you will get yes, in mega subscription offer you will get extended validity till next preliminary examination in minimum 1 year of subscription. There is no cost EMI offered with the subscription and 10% discount using referral code RBI Live. Then we have covered conflicts in India's federal system, center-state relations, the demands for autonomy, then role of governors and president's rule, demands for new states, interstate conflicts, special provisions for other states and Jammu and Kashmir. Then we have discussed about the local governments, where introduction, why local governments, the need of local governments, with the two stories of the Jamunia Talab Gram Panchayat and Vengivesal village in Tamil Nadu. Then we discussed about growth of local government in India. Lines by Mahatma Gandhi, the independence of India should mean the independence of the whole of India, and independence must begin at the bottom. So thus every village will be a republic. Then local governments in independent India, we discussed about 73rd and 74th amendments introduction and 73rd amendment in detail. Now, in next part, in 73rd Constitution Amendment, we discuss about three-tier structure, elections, reservations, transfer of subjects, then the subject listed in the 11th schedule, state election commissioners, state finance commission. Yes, that's it. Now, from 74th amendment onwards, we'll discuss in the next part. Till the time, keep studying, keep revising. So do not forget to attend next part of our marathon session of class 11th NCRT. Friends, please like, share and subscribe Unacademy videos. See you in the next lecture. Till the time, keep studying, keep revising. Stay home, stay safe. Take care.